these cases, Justice Scalia is being principled, and hats off to him for being principled. I think that, I said earlier, I think everybody believes that original intent or understanding or public meaning or something of the kind matters. I said that before originalism, I think that justices of the Supreme Court, for the most part, didn't have fully developed constitutional theories or weren't even aspiring to have fully defensible constitutional theories. I think something like the informal working understanding of justices of the Supreme Court prior to that time would have been something like adhere to the original intent or understanding as best we can discern it, except in cases in which the costs would be too high. And to a certain extent, I think that's what Scalia is doing in these cases. He's adhering to the original intent or understanding in a case in which the costs aren't too high. Talk to him about Bush against Gore.
Since we're here at a law school, let me ask another question, which is, are judges really equipped to be engaging in this originalist interpretive mode? Do they have the training that they need to have to engage in genuine originalism? And are law students today getting that kind of training in our law schools?
No, and that's not a bad thing.
Professor Prakash, you have any?
Well, I think there are more professors in law schools who are more sympathetic to originalism and might be introducing their students to those methodologies. Certainly as there are more originalists on the bench, it's become necessary for professors, even those who don't agree with the theory, to make sure that their students are exposed to it. So if your question is about the present crop of judges, I don't know the answer to that. But if you're talking about the students, I do believe that they're getting certainly exposed to the theory in ways that might not have been true before.
I think the important question is less whether they're being exposed to the theory than whether they're being exposed to the means of practicing the theory. The problem for me with originalism is, among the many, is translating theory into practice.
And I think one of the ways they're being exposed to that is through the Supreme Court, the decisions the court has that they're presumably being taught in the classroom. But I mean, without more decisions, they're not going to get that. Let me maybe throw it out to the audience to see if you all have questions for our panelists.
Okay. Hi, David Bernstein, George Mason Law School. So as I understand Originalism 1.0, shall we say, there were sort of two competing tracks for originalism. There was the sort of political / judicial track where conservative Republicans, judges, and political figures start using originalism for, sort of selectively in current controversies. Then you have the academic track where you have a lot of wonderful historical work by Randy Barnett, who I saw walking before, by others about things like the Commerce Clause, non-delegation clause, executive power, and on and on. And the court the court is, as Professor Fallon and others have mentioned, has been rather selective about which of these they've chosen to engage with. So they engage with originalism with the Second Amendment and the 11th Amendment and others, but they don't really engage in it with regard to the First Amendment, the Commerce Clause, and a whole bunch of other things. So while all this great academic work is being done, it hasn't affected a lot of constitutional issues. So it strikes me that Originalism 2.0 would be whether there is some theory or people who are working on theories whereby you could sort of meld the academic work into a plausible constitutional doctrine that judges will actually be willing to apply. It's, I think Professor Fallon and maybe some others said, judges aren't going to apply something that's completely makes them seem like nuts. But on the other hand, I don't know of any originalists in the academy who accept the idea of faint-hearted originalism, where you sort of pick and choose based on the political consequences, as being principle of originalism. And just one last thing on this, the argument that we can't go back on certain things, the two arguments I've seen made is, well, it would be too disruptive or the precedent's been around too long. That was sort of persuasive when I was in law school in 1988 about Roe v. Wade, but now it's been around 37 years and would obviously be extremely disruptive to American life, to American politics, to people to sexual mores that have grown up with abortion. I don't think an argument flies. I don't think you can make a principled argument. We can't go back on Roe v. Wade, but go back on everything else. So are there people working on trying to get the academic track and the political track, judicial track together, or are we sort of just living in an inevitable post-constitutional age?
I think we're living in an inevitable post-constitutional age, but and we have been for a couple hundred years. But it's but having said that,
Fallon was the first mistake.
Having said that, I think though that there's a various ways in which you wind up connecting these two things. I mean, one, right, scholarship penetrates into the political arena in various ways. I mean, one is you break into the public sphere more generally, such that certain kinds of arguments about constitutional meaning become part of the political discourse more generally, and originalism itself as a discourse about how to interpret the Constitution is an example of that, right? It breaks into the public arena and people start publicly, the general public, political elites in the public talk about that, and it catches on. You can do that about substantive provisions of the Constitution more generally, and judges will eventually pick up on that. The other way is litigants, can push through briefs to the court particular historical arguments and try to make those relevant to the particular issues that the court is trying to decide, in part by building on pre-existing scholarship, right? So there may be a pre-existing scholarly base about for example, so you mentioned the First Amendment not penetrating, but one of the places where the First Amendment historical scholarship I think has penetrated to some degree is relative to the religious liberty clauses. And so, you have a pre-existing base of scholarship on that. You push it through litigation about how that's relevant to the kinds of issues the court is interested in and the litigation is interested in. Then you have justices on the court or judges on the bench who are potentially interested in those issues, and then to what degree do they pick those arguments up and run with them, maybe faithfully, maybe not so faithfully, but to what degree do they try to reuse them for particular purposes, and some of them creep into opinions. And so, you push on lots of fronts in the scholarly world, and then you see what sticks through these other kinds of venues. But I don't think you can predict very easily ahead of time what's going to work or what's not. So, you may write an article saying the Commerce Clause needs to be revisited. Doesn't necessarily mean the Commerce Clause is ever going to get revisited, but you're right about something else as well, and maybe that will.
How about over here?